Well, I think I have met and touched everybody who's walked into this room tonight. So I am thrilled to be with you this evening. I would like to introduce to you my assistant, Kevin Dobbs. Kevin is in the back here. When we are finished, if you have further questions that we don't have time to answer this evening, make sure Kevin knows that, and I'll be making phone calls to you because I want to make sure your questions get answered, okay? All right, so tonight, we're going to see how good I am at being ambidextrous, okay? Microphone one hand, clicker the other, so wish me luck here. Okay, so tonight, before we get started, I want to get us in the mind frame of what we're going to talk about. It's a heavy discussion, but it doesn't have to be. So we're going to do a little exercise, and I'm going to call on several of you. Jesse, pay attention. Okay, good. All right. Okay. So in New Orleans, remember the Hurricane Katrina? All the devastation, horrible, horrible things happened. Well, some good came out of that. And one of the great things that happened is the community came together, and on one abandoned building, they made a giant chalkboard, okay? And there was chalk there. And the title was, "Before I Die, I Want to." Okay? So before I die, I want to ride a bull. That's what I want to do before I die. I know. Rose, a real one. Jesse, what do you want to do? Okay, I'm coming back to you. Oh, I love that. A best grandpa he could be. Patricia, how about what do you want to do? Okay. Okay, 5, all right. May it be, may it be. Okay, so Louise, how about you? What would you like to do before you die? Okay, okay. So what this shows you is it makes you stop and pause and realize that we only have a finite number of days. So use every day, enjoy every day. And what I want you to know is when we leave, those that we leave behind, we need to make their life as easy as possible, okay? That's why we're here tonight. So I am Susan Muscari. The name of my law firm is Muscari Law. I have 2 offices. I'm licensed in 2 states. My primary office is in Grove, Oklahoma. My secondary office is here in Tulsa. I'm an old Tulsa lawyer. I've been doing this for 30 years and I love it. So I've been with the credit union 20 years. When you are looking for a lawyer, I'm not clicking. So sorry. Oh, now we're clicking. Okay, now we're good. Excuse me. So the first thing on an estate is, what in the world is it? Most people, when they come to visit with me, they'll say, "Susan, I don't have an estate." Well, guess what? Every one of us in this room does. And here's what an estate is. It's your home. It's your money in your checkbook, your savings account. It could be your investments, your stocks, your bonds, your certificates of deposits, your retirement accounts if you have them, 401ks, IRAs. It is the multitude of stuff that we all have in our homes. The furniture, our clothing, our jewelry, our firearms, fishing equipment, tools in the garage, and then of course insurance policies. So when you stop and think about it, we really do have more than we ever think. So the next question you should have is, why do I need to have an estate plan? What is the purpose? What is the reason for this? So the reason for a plan is that after death, you know who is going to get the things you have worked so hard for, and you want to reduce or totally eliminate any legal fees. That would be attorney fees. It would be taxes, any court fees. Now, I work hard for my money. I'm very tight with my money. I'm extremely tight with my clients' money. That's the way you accumulate and move forward. But also the other reason for an estate plan is a pesky incapacity issue. 60% of us in this room tonight will become incapacitated prior to our death. And if you do not have a plan in place, it is going to be ugly, not only for you, but for your family. So later, we're going to talk about how to make sure that doesn't occur. So who needs an estate? Every one of us here. It doesn't matter whether you're single, whether you're married, whether you have a family, whether you have no children. Every one of us needs to have a plan. And here's the reason why. If you don't, the state of Oklahoma has a plan for you. And I guarantee you, you will not like it. Okay? Excuse me. So in the news, celebrities come and go. They die just like the rest of us. And we've got some really good examples and some bad examples. Prince had a $300 million estate when he died. Zero plan in place. It's been all over the newspapers. It has been in TV. It's been in all of the Globes, the Inquirers, all of that sort of thing. What a mess. Legal battles all over. The same with Michael Jackson. $2 billion this man was worth. Zero planning. Zero. Again, he's gone. His family is suffering. They're tied up in litigation and in the court system. Robin Williams, our famous funny man. No planning. Same thing. But who don't we hear about? Whitney Houston. The woman had a plan, and it was a good plan, and there is no court involved. So we want to be Whitney Houston. So let's go back in time. I think everybody here is of an age who remembers Elvis Presley. Am I correct? Blue suede shoes? Oh, doesn't get any better. Okay, so Elvis, when he died, he had an estate worth a little over $10 million. Okay, a lot of money back then, still a lot of money today. But Elvis, he liked that bling, didn't he? So he spent a lot of money. At the time of his death, he owed $3.8 million. That's a lot of glitter, okay? Because he did not have an estate plan, everything went through the court system, which is called probate. Probate cost just under $2 million. Look at that tax amount, $3.3 million. Do you see what Lisa Marie ended up with? $986,000 out of $10 million. That is criminal. My goal through my law offices is not to have that happen to our clients. That is criminal. There is no reason that that should have occurred. He did not plan. His family suffered. Okay, does anybody remember Groucho Marx? Okay, oh, thank goodness. Okay, so Groucho Marx, big mustache, big cigar, okay? Groucho's story is even sadder. Not only didn't he plan for his death, but he never dreamed he would be incompetent or incapacitated prior to his dying. So here's what happened to poor old Groucho. He was involved in 2 court actions. The first was an adult guardianship because he was declared incompetent by a court, which means he couldn't make his personal or own financial decisions. Kind of scary, isn't it? So what happens? The court comes in and goes, ooh, we're going to appoint this person to be your legal voice and make decisions for you. Ladies and gentlemen, we do not want the court assigning anybody to our assets or our affairs. We can do this differently, and you can choose your own person to make those decisions. So if you're declared incompetent, you've lost full control of your assets, full control of making your own decisions. Oh, guess what? There's no privacy. We can go read all about it. And the cost, not only financially, but emotionally for the family and for the person themselves, is high. Again, remember, we're tight with our money. Let's not waste our money like Groucho, okay? All right, so when should you plan? You need to plan now, okay? You're competent now. You're alive. This is the time to do it. A lot of people will wait, and wait is what sunk the ship, as my husband would say, because if you wait too long until there's a healthcare crisis or a problem, that person may not have the capacity to sign legal documents. And if that is correct, guess what? You're going to be Groucho Marx, and we don't want to be Groucho, okay? So plan now. There is no second chance. Always look at it and pretend, what if I had an illness and tomorrow I couldn't speak, I couldn't write, you're locked in? How are you going to make sure that what you want done is done? And that comes through your legal documents. So remember, no second chance. Please don't wait. So let's talk about some common estate plans. Now, I'm just going to briefly touch on these because of our time allowance tonight. But there are 6 plans. The first one you all may be familiar with. It's called the Last Will and Testament. A lot of times our parents and our grandparents use this planning tool. Then we have doing nothing. That's when you're so overwhelmed, you're going, I'll be gone. I'll just let them figure it out. Let's not do that, okay? Then you have joint ownership, giving away assets, using beneficiary transfers, and then lastly, you might consider doing a revocable living trust. These are all valid plans. Some are really good. There are 2 there that are just absolutely horrible. Can you guess which 2 those are? Absolutely correct, Patricia. Doing nothing and giving assets away, absolutely the worst thing. Please don't do that. Okay? So let's talk about a last will and testament. What I want you to understand is this is an old traditional planning tool. It still works today. Okay? A will expresses your wishes. They're not mandatory instructions. They're wishes, what you're hoping will happen. The will controls assets that are only in your name. Okay? A will require the probate court to be involved. We'll talk about how you can skip one, but the second spouse, when they die, there will be a probate. So remember, will, wishes, court involvement. So what is probate? Probate is a dirty word. It really is. Stephanie, quit laughing. I see that. Okay, so probate is a dirty word. And the reason is because you're in front of a judge. You've got a bunch of attorneys there. You're not there because what? You're dead, okay? But who's there? Your spouse, your kids, your loved ones. Don't put them in this position. It is frustrating at best. It is a process. It takes 18 to 24 months to get through the court system. In my law firm, we do everything we can to keep our client families out of the legal system. So I want to give you an illustration of probate. And I want you to think about a big white funnel. See it up there? Here's what happens. You die, all of your assets drop into that big funnel. And then here's what occurs. The court system and the attorneys get a hold of that funnel and we start swishing it around and swishing it around. And eventually things are going to drop out of the bottom. And the first is going to be taxes, funeral expenses, creditor claims. Everybody's going to get paid. And then if there's anything left over, it goes to the heirs. It depends on the plan how much drops down into that funnel. The goal is nothing drops in a probate funnel. Got it? Okay. Probate's big business. I have a lot of attorneys that I know that will lowball for a last will and testament because they know they're going to get the probate on the other end, which is big business. Don't fall for that. Ask your questions. $1.5 billion a year is paid out to attorneys on an annual basis to do probate cases. That money, in my opinion, should have been in family pockets. Don't you agree? Absolutely. Millions are paid out to bonding companies, appraisers, and filing fees with the court systems. Again, big old waste of money. So not only are you wasting money, you're wasting time, and you're also wasting your emotional energy on a system that truly is not in your family's best interest. As we spoke, Probate on a good case is about 9 months. That means nobody's fighting, nobody's arguing, and you got one lawyer. Now, I can say this because I am an attorney. You get 2 lawyers in a case, and you are off to the races because we are trained to be pit bulls. We are trained to fight for our clients. So don't get in that situation. Avoid probate. Probate is another dirty word because it's public record information. So let's pretend I died. You all have met me. You all know my name. You know that I'm here in Tulsa County. The probate would be filed in the county that I live within. You would be able to go down, tell the court my name, and say, I'd like to see that file. And the court clerk is going to hand it to you. And you're going to be able to sit there and say, I'd like a copy of this and that or the other. So let's talk about what is in that file. Greta, what do you think's in that file? Everything, absolutely correct. So what's in it is not only my name, my date of birth, my date of death. Oh, my death certificate is going to be there, which has what? My social security number on it. Then it's going to list everybody that I love that I'm going to leave a gift to. Oh, not only their names, it's going to give you their addresses. You can send them a Christmas card if you want it, okay? So you can see the danger of that type of information being out public record anymore. 50 years ago, we didn't have what we have now. So be very careful. Probate is always easy to contest because guess what? Everybody can read all about it. There might be, gentlemen, especially this happens, they pass on, a probate is filed, and guess what? Some kid pops up from wherever that may or may not be your child, but makes the claim that they are. So what does that mean? Oh dear, more court, DNA tests, and it's a mess. So again, what is the rule? Avoid probate. Probate has control. It interprets whether your will is valid. If the wishes that you put in your will are something that is allowable by Oklahoma law, we've talked about cost, time, and privacy. So again, what is the rule? Avoid probate. You got it. All right. So let's talk about the other difficulty with a last will and testament. A last will and testament is a death document. It does nothing for you while you are living. It only comes into play at the time of your death. So remember that incapacity issue with Groucho Marx? Okay, if you become incapacitated, you would have an adult guardianship, unless there was another plan, plus a probate at the time of your death. So what does that equal? Double attorney fees. Stay out of court. We don't want to go there. So an incapacity hearing, which is an adult guardianship, is very expensive. It is time consuming. Oh, well, you know, there's going to be a file people can read, and it doesn't replace probate. So that's why you've got the 2 different cases. So Patricia, the fix on that is what we call a durable power of attorney. Some of you may be familiar with that document. And what it does is it protects you because you're going to name who's going to be your legal agent should you become incompetent. So what does that do? Big King's X, no adult guardianship. It's a wonderful document we all need to have. Now let's continue with the last will and testament. So more than likely everyone here has some grandchildren that are underage. And if you are leaving a gift to an underage person, the probate court is going to get involved. They're going to demand how that money is to be set aside, and they will monitor it until the child attains the age of 18, and then the kid gets it all at one time. Okay, think about when you were 18. Kind of a scary moment in time, wasn't it? Okay, so if you came into a bunch of money, what were we going to do? Well, we're going to buy a new car, Thomas, aren't we? Stephanie, we're going to have a party, aren't we? Yeah, of course we are. Yeah, we'll probably buy some new clothes, Greta. What do you think? Yes, okay. So do we give an 18-year-old a whole lot of money? Never, 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 never. So again, that's the problem with the last will and testament, but there are ways to get around that. So doing nothing, I bet right about now, that sounds pretty good, doesn't it? Let's just leave it for them to sort out. Please don't do that, because guess what that does? It takes you immediately into the court system. Now, again, remember, we're gone, but it's our families, our loved ones that are going through it. Same thing with incapacity. If you do nothing, you become incompetent. There will be an adult guardianship. I do them all of the time. They are ugly, they are brutal, and they are messy. So again, let's not get in that place. Joint ownership. Oh, now you guys are going to know all about this. Think about your property. Thomas, Patricia, I bet that you have checking accounts or you have a home that you own together, joint tenants with right of survivorship. Okay. Does everybody know what that means? Okay, well, let's talk about that. Everyone thinks it means we both own the property. Well, simple language you do, but let's drill down to truly what it means. So for Patricia and Thomas, their home, they both own it, joint tenants with right of survivorship. What it means is they both own an undivided 1/2 interest. Okay. If one of them passes on, the survivor is not going to probate court. They inherit it outside of probate, but they must file the death certificate in land records to assume the title in one particular name. So that's joint tenancy with right of survivorship. It sounds good, it looks good, it smells good. Guess what? It tastes really, really bad, because let me show you what happens, okay? Here we have Tom and Ann, husband and wife, 3 cute little kids, okay? Life is great. They're married, family's intact. Tom dies. They have everything in joint tenancy with right of survivorship. He dies, Ann inherits everything, no probate. Whoop, whoop. Good job, all right? Then Ann, when she dies, there will be a probate, and her heirs, hopefully those 3 little kids, will inherit. But that's not necessarily true. So let's go forward a few years. Remember, husband 1 has died. Ann has now remarried, and she's married Dan. Okay? Ann remembers how well it worked with husband number 1. When he died, there was no probate. So they put everything in joint tenancy with right of survivorship again. She dies first this time. He inherits all. What's happened to those 3 little kids? They get nothing, do they, Stephanie? Okay. This happens every day with blended families. Every day. Paul, you're shaking your head. Yep, you've seen it. You've experienced it. Yeah, it's brutal. So again, there are things that we can do to avoid this from happening, but you got to plan, okay? So joint ownership, just to summarize, you'll avoid the first probate on the first death. The second death, if there's no further plan, you're going to probate. You can unintentionally disinherit children and other loved ones very easily. Oh, and now look, we've got that pesky incapacity issue again. There's no plan in place with joint tenancy for incapacity. So I have some clients that will come to me and they'll say, oh, Susan, I got this figured out. My spouse died and I've added my kid to the deed. Run down to the courthouse and take that off immediately, okay? Worst thing you can do, because think about it. What have you done? You've given your kid or children an undivided interest in your property, okay? They're younger than us. They're still learning to spread those wings and fly. So what do? They're going to stub their toes and make some mistakes. They could file bankruptcy. Guess what? Your property's in jeopardy. They could have a creditor claim. Guess what? Your property's in jeopardy. Oh, here's a goodie. What if they have a personal injury automobile accident and are at fault? Well, kiss it goodbye, because an attorney is going to look for anything that that person's name is on to gather up as assets. Now, you won't lose 100%, but you'll lose their interest, which oftentimes forces you to sell your property. So please do not put your children on your assets, whether it be your home or whether it be a credit union account, a bank account, an investment account. Don't put your children on as joint owners. There's better ways to do it. Okay, shall we just give it all away now? Be done with it? Kind of, did you? Oh dear. Okay. Did it work out? Okay, so Patricia's aunt was very fortunate. We never give assets away. Never. And here's why. I don't see an expiration date on the bottom of my foot. Do you guys have one? Do we know when we're going to leave? No. What if you give everything away and you don't have enough left to take care of yourself? Okay, so that is a unique situation. I'm so sorry, excuse me. Yeah, no, that's okay. All right. Yeah, you choked me up on that. Okay, but you lose control of your assets. And oftentimes people will think, oh, I'll give everything to my kid. That's going to avoid a Medicaid claim. They'll happily help me if I need it in the future. Thank you. Thank you. I promise you, Stephanie is not a ringer, but that's absolutely correct. Don't count on your kids helping you, because here's what happens. They're struggling. Every kid out there is struggling right now. And if you give them 5,000, 50 cents, 10,000, whatever it is, they need it to go forward. They're going to spend it. They're going to tell you they're not going to spend it, but they're going to spend it. And then you're going to need it, and then they don't have it. So let's not put them or you in that position. Okay, so please don't give anything away. Now, there's always an exception to the rule, though, isn't there? Okay, so the exception to the rule, Patricia, is let's say Christmas is coming and you have a specific item you want your kid to have and to make sure they have it. Slap a bow on it, give it to them, and say, Merry Christmas. If you ask them to take it, they're going to say, no, Mom, I don't want to do this now. I don't want to talk about this. But if you put a bow on it, give it to them, they've got it. Okay? So anything that's really important to you like that, family mementos, memorabilia, anything like that, go ahead and give those assets away. So beneficiary transfers. David works a lot with this in his financial planning, his wealth management practice. Beneficiary transfers, I love. They're beautiful because you can specifically name who is to receive that asset at the time of death. But there's kind of a trick to it. You have to name a primary beneficiary. That's the one, when you die, if they're living, they will receive it. But if that beneficiary has passed on, you need to have a secondary beneficiary named, or otherwise it's going to go to probate. Now, some people will say, oh, I'm just going to name the primary. If they die first, I'll come back in and change it. Well, here's the problem. Guess what? We're aging right along with them. Our health could deteriorate, and you may not have the legal capacity to add a different beneficiary. So when you're sitting down with wealth management and you're going through beneficiary designations, always remember a primary and a secondary beneficiary. Okay? Again, never use as a beneficiary my estate, because, oh my goodness, Gary, what does my estate mean? We don't know, do we? Who's going to define it? The court. Okay, so we don't want to do that. Never list a minor child. That's problematic also, and David can go into all of that with you on an individual basis, but you've just opened the door again for the court system. So beneficiary transfers are fabulous. Make sure that you have them on all of your credit union accounts, your bank accounts, any of your wealth management accounts, primary and a secondary. Okay, so now I want to talk about what lawyers like the best, because with this, we can be assured that our clients are taken care of. With a revocable living trust, and it can be used for married persons, single individuals, it can be used with blended families, can be used with all different types of assets that you can segregate, put some in, leave some out. We can do all sorts of creative things. But keeping control with a revocable living trust is a unique way to plan your estate. This is not a new planning tool. It's been used for hundreds of years. You remain in control. You name who your legal voice is should you become incompetent. You will set out a distribution plan. And oh my goodness, we can be creative. We don't have to give it to everybody at one time. We can do a structured distribution, do it over a period of years. It avoids probate. It will also avoid an adult guardianship, pesky incapacity issue. All of those things are taken care of. So think about a trust as a timeline. You have right now, today, we're competent, we're living, life is great, you've got a plan in place. Go down the timeline, either you or your spouse may become ill, become incompetent, there's going to be a plan in place. When the first death occurs, guess what? There's going to be a plan in place. When the second death occurs, we have a plan. And so I'm a Star Wars fan, so it's and beyond. Okay, we can take it a while and beyond. Okay, so when you create a trust, right now you all own things in your individual or joint names. We're going to change that ownership to the name of the trust. It sounds really hokey, but the trust owns, you possess, and you control. So you're not giving up any control. Think about the funnel again. When you look at these two funnels, the trust funnel, we're going to drop all of the ownership of the assets into. And when death occurs, see what comes out the very bottom? To the beneficiaries. That's who we work hard for, isn't it? Look on the left-hand side. Nothing goes to probate. I like that. How about you? Okay, so this is an option plan that you can use. You keep control. There is no restrictions on you. You can buy, you can sell, you can give away, you can change it at any time. Let's say somebody takes the stupid pill, okay? It happens. You can change their share. You can take them out of the trust. There's all things we can do. So there's certain language that a trust uses. If we were doing trust planning, I would go into detail on all this. The best way to think about it is the trust is like a giant umbrella, and it's going to protect you. And what's going to happen is at the end, your beneficiaries are going to receive everything that you've worked hard for. There will be no court. Yes, yay is right. You can also name a corporate trustee. It is not used as much as it was in the past. Generally, it is husband and wife or an individual who is the trustee, and then you name your successors. What you want to do is when you're naming a trustee, make sure that they're strong enough to stand up and say, no. Little tiny word, but it's very powerful. Okay, so I want to introduce you to Spike. I love Spike. Isn't he handsome? Beautiful red hair. Look at those spikies up there. Look at all the hardware on his hands. And I guarantee you under that jacket, there's a ton of tattoos. Okay? We've all got a Spike. We all have a Spike. It could be a person who's into drugs and alcohol. Could be a person who loves to gamble. It could be a child of ours who really likes to marry and divorce, marry and divorce, marry and divorce. Okay? Spike comes in all shapes, forms, and fashions. Spike could also be a kid who's having a little bit of a struggle learning how to get those wings out and fly. Okay? Doesn't mean the person's a bad person. They're just struggling. Our duty as parents, grandparents, is to help lift Spike up. But if he truly has taken the stupid pill, then our duty may be to structure his inheritance. If that person has gone way off the edge, we may take them out of the estate plan for a while and see if they can grow up, okay? So Spike is very important to all of us. And when you're looking at your family, remember, just because they're Spike doesn't mean they can't change, okay? So a living trust seminar is going to avoid probate at death. You have full control of your own assets. It will prevent an adult guardianship. You have privacy. There's nowhere to go read all about it, okay? We prevent unintentional disinheriting, and it will reduce or totally eliminate any tax liability. Now, I've hit the high spots. There's way more to this than involved, but I wanted to give you a flavor of what a trust is. Now, lastly, I want to talk about living wills. And I know it's getting warm in here. I'm getting a little warm myself. But this, to me, is the most important document that each one of you here should have. It's called an Advanced Healthcare Directive. I have a folder over on the table. It's blue. Make sure you all pick it up. What this document does is gives you the right under Oklahoma law to say, if you knew you were dying, not just a little sick, you're dying, do you want to be put on life-sustaining treatment or not? Do you want to have artificially administered food and water or not? Here's the blessing. There's no right answer. It may be different for all of us, but you must get it in writing on the proper form, because Oklahoma, we have some really old, ugly law on the books, which says if you do not have that, our medical professionals, our hospitals can be sued for homicide. So if it's important to you the way you leave this world, get this document in place, okay? So I want you to think about a 5-step action plan. What are your objectives? What are you hoping to accomplish by making a plan? You should have 2 documents right off the top: an Advanced Healthcare Directive and a power of attorney. That's your starting point. I want you to look at your assets. Just kind of walk around the house and go, oh, I got more than I thought I've got, okay? Look at your vehicles, your toys, your boats, your motorcycles. All of that is included as part of your assets. Find an attorney to help you. Whether you come to me or you hire another attorney, get it done. Just get it done, okay? Get the legal documents prepared. Please do not go online and pull off these online documents. They are worthless. You're wasting your money. I take them to court almost every week. It's a mess. And then if you create a trust, or if we're doing some other types of transfers, we want to make sure that the titles are changed. Get everything in order. So here's what we want to do. We want to walk off into the sunset, don't we? Okay? That's what we want to do. So this is the conclusion of the slide presentation.